The government's move to disestablish the Māori Health Authority is being challenged in court today. The applicants want the court to confirm it can issue a te tiriti declaration of inconsistency and to uphold the Waitangi Tribunal's 2024 Hautupua report, which found multiple treaty breaches. Joining us now to talk about what's at stake is Dr. Chris Tooley, Chief Executive at Te Puna Ora o Mātātua and co-applicant in the case. Kia ora, good morning to you.
Morena.
Can you just outline for us on what basis are you able to ask the court to rule here?
So in this case, we're seeking a statutory declaration in relation to the rights of te tiriti. And so in doing so, we're asking it to uphold the Waitangi Tribunal's findings that it found earlier this year. Previously, the government hasn't acknowledged these findings, and so we're putting it to the court that how can the courts of New Zealand validate the findings of te tiriti and validate the findings of the Waitangi Tribunal? We're hoping that this will enable a shift to move towards a national conversation around remedies, especially for the disestablishment of te aka whai ora in our case. There's a growing movement internationally where governments are starting to recognise constitutional rights and interests of different populations in relation to common law, customary law, international instruments, and not simply rely on the statutory power of Parliament.
So what would be the implications of getting that statutory declaration? Does that then clear the way to actually re-establish this disestablished Māori authority? Or what's the outcome that you are looking for?
So huge ramifications across the judiciary. If we get a statutory declaration, it means it will validate the findings of every Waitangi Tribunal claim that's gone before the Waitangi Tribunal. It will allow all different claims to therefore seek a conversation about remedy through the courts rather than relying on governments of the day to come to the party and to negotiate what that may mean.
So that's huge. This is not just this particular issue. This is all of the issues that the Waitangi Tribunal has issued decisions on.
It's massive, and we're bringing this case because time and time again governments have failed to validate the findings of Waitangi tribunals. They've gone into an abyss where no one really knows what's happening. The interesting part about this case is that, this is the second hearing today, and in the previous hearing, there's a general consensus that the Crown has breached te tiriti of Waitangi, even from the Crown lawyers. And so the Crown is now trying to figure out what actually happens to those findings and how are they enacted upon. And if the government isn't going to enact them, then how can the High Court validate those findings, because the Waitangi Tribunal is a part of their court system? How can they move forward?
Given that this would be precedent setting, are you expecting a bit of an uphill battle?
It's going to be a very big uphill battle. We're thinking that even though the conditions are right for the High Court to uphold this case, there's certain long-established precedents that we're challenging. And so in either case, both parties are likely to appeal. And so we're on the long kind of conversation here, and we're expecting this to go all the way to the Supreme Court.
Right, so we're going to have many more days in court than just 3 this week.
Yes.
We'll be watching this one with interest. Thank you so much for your time this morning, Dr. Chris Tooley, the Chief Executive of Te Puna Ora Mātātua.